Good morning, and welcome to Commission's hearing this morning in docket number 2019-362A. We will call this hearing to order. First order of business will be a roll call of commissioners. District 1.
Commissioner Williams is attending virtually.
District 3.
Oh, present in the hearing room.
District 4.
Attending virtually due to COVID-19.
District 5.
Thomas is present in the hearing room.
District 6 is not present at the moment. District 7.
Howard is present in the hearing room.
And I'm from District 2, and I am present in the hearing room, obviously. At this point, I'd like to take roll call of the parties, just to make sure we've got everybody online. We have Ms. Boyd, who will be presenting. Is there someone here for Duke Energy Carolinas and Duke Energy Progress?
Good morning, Madam Chair. I'm Katie Brown, in-house counsel for Duke Energy Progress and Duke Energy Carolinas. Here with me today is Frank Ellerby from the Robinson Gray Law Firm, and he will be delivering our comments.
Thank you and welcome. Anyone present from Dominion Energy, South Carolina?
Madam Chairman, this is Matt Gissendanner from Dominion Energy, South Carolina. I'm corporate counsel for the company. With me today is Mr. Mitchell Willoughby and Mr. Andrew Hand, both of the law firm of Willoughby and Hafer, and Mr. Willoughby will be presenting the company's comments today.
Thank you and welcome. Johnson Development Associates Incorporated.
Yes, ma'am. Weston Adams with Nelson Mullins, and I'll be presenting the comments for Johnson Development today.
Thank you,
I've
Mr.
got my colleague Court Walsh here with me as well.
Thank you and welcome to this morning's proceeding. Also parties but have been excused at their own request are the South Carolina Solar Business Alliance, South Carolina Coastal Conservation League, and Southern Alliance for Clean Energy. Anyone present for the Office of Regulatory Staff?
Good morning, Madam Chair. This is Jeff Nelson on behalf of the Office of Regulatory Staff.
Thank you, Mr. Nelson, and welcome. And is anyone from the South Carolina Department of Consumer Affairs with us today? Okay, thank you very much. I'll now recognize Ms. Wessinger-Hill for the reading of the docket, please.
Thank you, Madam Chair. Madam Chair and Commissioners, we are here for the proceeding in docket number 2019-382A, which is the rulemaking of the Public Service Commission to create a new regulation 103-811.5, which is the role of the qualified independent third-party consultant and expert, and the Commissioner's reliance on the contents of the qualified independent third-party consultant and experts report. The proposed regulation is necessary to provide guidance as to the role and responsibilities of the qualified independent third-party consultant and expert and the Commission's reliance upon such report. The notice of drafting regarding this regulation was published on December 27, 2019 in the State Register, Volume 43, Issue 12. The final regulation before you today was submitted to Legislative Council on August 14, 2020, and then published in the State Register in Volume 44, Issue 8 on August 28, 2020. The public notice of hearing and opportunity to be heard advised that any comments must be received no later than 4:45 p.m. on Friday, October 2nd, 2020. All interested members of the public and the regulated community were invited to make oral or written comments on the proposed regulation at the virtual public hearing to be held today before the Commission. Madam Chairman, it is my understanding that our technology is fully functioning and that all parties to this proceeding that are requested to participate in this matter are here unless they've otherwise been excused. I would ask that all parties please make sure they announce their name before they speak and also beware not to talk over anyone else in order to assist our court reporters since these proceedings are being recorded. Madam Vice Chair, the docket is in order.
Thank you, Ms. Hill. And thank you for that reminder, and I would ask that anyone needing to get our attention to speak, whether, especially if somebody else is talking, to please state your name. Sometimes it's difficult to recognize voices, and it just helps the court reporter and helps us as well to know who is speaking. I think first up, we will have Ms. Boyd, Ms. Jocelyn Boyd, Executive Director and Chief Clerk of the Commission. Ms. Boyd?
Good morning, Madam Chair. Thank you. The first task I'd like to complete this morning is being done pursuant to South Carolina Code annotated section 1-23-111. And that section A requires the agency to submit into the record certain jurisdictional documents. And at this time, I would like to ask that the following documents be submitted into the record. They include a copy of the notice of drafting, which was published in the State Register on December 27th. And so the first copy I have here is a copy from the State Register. The second document includes a compilation of the comments that the Commission staff prepared of comments that had been filed in the docket management system under docket number 2019-362A as of July 1st. And the first page of that document includes a copy of Code Section 584120, and then on the third page you'll find comments from Duke Energy Progress, Duke Energy Carolinas, Dominion Energy South Carolina, Johnson Development Associates, and South Carolina Solar Business Alliance. The next document I'd like to ask to be submitted is a Word document that can be found on the scstatehouse.gov webpage under document number 4988. It is a complete copy of the proposed regulation. The next document is a copy of the proposed regulation as it appears printed in the State Register on August 28th. And then the final document is the document that I filed with the Legislative Council on August 14th. I just ask that these jurisdictional documents, including the exhibit that's filed on DMS, be submitted into the record.
That compilation of documents will be marked for identification as hearing exhibit number 1 and entered into the record of this proceeding.
Melissa, I need to move to the PowerPoint. Okay. Okay, Madam Chair, I would like to next move into a brief PowerPoint regarding the proposed regulations, regulation that is before the commissioners this morning.
Before you proceed, can all of the, can the parties and commissioners participating virtually see this slide on the screen?
I'm sure they can.
Okay.
Yes.
Please proceed, Ms. Boyd.
Okay. So I won't repeat the information that Council Wessinger-Hill stated during her introductory remarks regarding the publication of the notice of drafting and the proposed regulation. That information is restated on this slide. I'll move directly now into the substance of the proposed regulation. So the proposed regulation, as you are aware, we've already been through the process, completed the hearing process for the Commission's procurement of a qualified consultant or expert under South Carolina Code annotated section 58-4120I. And this is, I guess we can call basically part 2 or phase 2 regarding the role of the consultant or expert that is employed pursuant to 58-4120I. First section, there's some points that I want to restate based on the proposed regulation regarding ex parte communications and the proposal that the consultant and expert sign an acknowledgement regarding ex parte prohibitions upon the commission contracting or entering into a contract for the consultant and expert services. So basically, subsection A states that the consultant and expert or experts are subject to the ex parte prohibitions contained in Title 58, Chapter 3 of the South Carolina Code. However, the consultant and expert, based on the proposed regulation, are not prohibited from communicating with the commission and with the commission staff. The consultant and expert will conduct its analyses under the authority of the commission, and the qualified independent third-party consultant and expert's duty is to the commission. Section C of the proposed regulation states that upon retention by the commission, the qualified independent third-party consultant and expert shall sign an acknowledgement of the ex parte prohibitions contained in Title 58, Chapter 3 of the South Carolina Code. You will also find a section in the proposed regulation under Section D, which covers a proposed schedule and strategy on how the consultant and expert plans to deal with ex parte communication prohibitions. So Section D states the qualified independent third-party consultant and expert shall submit a proposed procedural schedule for the timing of the development and issuance of its final report and its intended approach to complying with the ex parte prohibition provisions and carrying out its responsibilities to the commission. Well, what about the consultant and expert's work? Section E, I think, covers some important information regarding the consultant and expert's work. Part of the consultant and expert's work will include its role in modeling its own data inputs and calculations via an independent analysis of an electrical utility's avoided cost. And the proposed regulation also provides the role of the qualified independent third-party consultant and expert is not to rely solely on inputs from the utility or any other party, so as to be constrained to working from the utilities or any other party's avoided cost data, inputs, and assumptions. So the final report, I just mentioned Section D, final report is mentioned in Section D of the proposed regulation. It's also mentioned in Section F of the proposed regulation. And before I get to that, Madam Chair, I wanted to refer back to the statute and just read into the record some information from the statute regarding the report. So the third sentence of Section 584120I states, the Commission shall engage for each utility a qualified independent third party to submit a report that includes the third party's independently derived conclusions as to that third party's opinion of each utility's calculation of avoided cost for purposes of proceedings pursuant to this section. Sentence number 6 under that same section I of 584120 states any conclusions based on the evidence in the record. I apologize, that's not sentence 6, it's sentence 7. Any conclusions based on the evidence in the record and included in the report are intended to be used by the Commission along with all other evidence submitted. So I just wanted to mention that report where it's mentioned at least twice in Section I before I talk about the proposed regulation. Proposed regulation regarding in reference to the final report basically states that the final report of the consultant and expert regarding that final report from the consultant and expert, that all parties shall receive the final report at least 10 days prior to the Commission's vote in the proceeding, and the parties must be given a reasonable opportunity to respond in writing to the final report prior to the Commission's vote in the proceeding. Another section of Section F that I've mentioned on my slide deck, the next bullet point, is related to discovery, deposition, cross-examination, and testimony. And the proposed regulation in Section F states, the qualified independent third-party consultant and expert's duty is to the commission, and the qualified independent third-party consultant and expert is not subject to responding to discovery, may not be deposed, will not be cross-examined, or called to testify before the commission. That completes my presentation.
Thank you, Ms. Boyd. Any questions of Ms. Boyd? We'll go through the parties appearing. Any questions from Duke, either of the Duke companies? Mr. Ellaby?
I don't think, Madam Chair, that we have any questions. We do have disagreements, as is clear from our comments, and I'll explain those, but I don't think I need to cross-examine or ask questions of Ms. Boyd. So thank you very much.
Thank you, Mr. Ellaby. Dominion Energy, Mr. Willoughby?
Thank you very much, Madam Chair. No, we would not have any questions of Ms. Boyd either. We have comments, and as Mr. Ellaby has said, we disagree with some of the provisions of the rule, and we would welcome the opportunity to explain those when given the opportunity to do so.
Yes, sir, that's forthcoming. Johnson Development Associates, Mr. Adams?
Yes, ma'am. Johnson Development fully supports the regulation as drafted. I do not need to ask her any questions, but we will have comments when the time comes for our presentation.
Yes, sir. Office of Regulatory Staff, Mr. Nelson?
Yes, thank you, Madam Chair. ORS has no questions, and we have not filed comments.
Thank you, Mr. Nelson.
We have no
Commissioners,
comments, Ms. Boyd.
anyone have any questions of Ms. Boyd? Do I need to do a roll call? It's a new proceeding. Okay, Ms. Boyd, thank you very much for your presentation.
Yes, ma'am.
I think we're going, I hope I've got the order correct, but the plan was to call on the parties in the order in which they filed comments, and the first one I have listed is Duke Energy Carolinas and Duke Energy Progress. Mr. Ellaby?
Thank you, Madam Chair. The Duke companies have we filed comments on February 13th of this year in response to the notice of drafting. We then filed on October 2nd additional comments and an attachment showing our proposed revisions to the proposed regulation. I would ask that our comments that we filed on February 13th and October 2nd be made a part of the record, maybe the next hearing exhibit.
Mr. Ellaby, the Duke comments, both sets, will be marked for identification as hearing exhibit number 2 and entered into the evidence of this case.
Thank you, Madam Chair. I'll go through and the comments we made in February when the notice of drafting came out raised some legal issues. The commission, the proposed regulation did not incorporate our proposed revision, so we have, in the comments that we filed on October 2nd, we again reiterated our concerns about legal issues with the proposed regulation. To explain our position in my comments, I think it'd be best for me to start sort of at the end of the process. This consultant will be submitting a report that will be part of the record in the case, will be admitted into evidence the commission is allowed to rely on that report in making its decision in the proceeding. And that is called for in Act 62. So that's a sort of starting point, that report that the consultant will prepare will go into the record and will be available to the commission to be relied on in making its determinations. That fact, that the work product of the consultant will become a part of the record and will be evidence, then dictates how that consultant's role needs to be managed. The consultant has to be treated like a witness in the case, not like a party in the case, because as Act 62 makes it clear, the consultant's obligation is to the commission. But the consultant, in order to provide due process protections to all the parties in the case, the consultant is going to have to take the witness stand and and testify, lay a foundation, testify, get that report into evidence, be subject to cross-examination by the parties in the case and the commission, and if also be required to respond to discovery with respect to the report. All of those things, those due process protections, flow from the fact that the consultant's report will go into the record and be part of the evidence in the case. I think that distinction is critically important because the consultant is not playing a role like commission staff and providing advice and counsel privately to the commission. Instead, once the report goes into evidence, that puts the consultant in a role as a witness in the case, and that means that consultant has to be subject to discovery. The legal principles, and we've outlined them in the comments that we filed. Most fundamentally, it arises from Article 1, Section 22 of the South Carolina Constitution, which provides that parties in administrative proceedings are afforded the rights of notice and an opportunity to be heard. The Supreme Court has said that you have to have an opportunity to understand and notice of the matters that are going to be submitted against you, or that you have to respond to in administrative proceedings. The Administrative Procedures Act also requires a notice, opportunity for hearing, opportunity to conduct discovery. Act 62 itself requires that the third-party consultant is subject to discovery and an opportunity for parties to understand in advance of the hearing what the consultant's opinions are and what the consultant's report is going to say. The critical defects in the proposed rule are that the report, that the consultant is not required to testify, is not subject to deposition or discovery, that the consultant's report is required to be filed 10 days before the commission votes, which will be, in every case, will be well after the hearing in the case. So the parties in the proceeding will not have an opportunity to respond to understand and respond to the report until after the hearing. So you don't have an opportunity to cross-examine. You don't have an opportunity to do any discovery about the report in advance of the hearing. And you don't have an opportunity to put your witness up to respond to the conclusions of the third-party consultant. All of that flows from the fact that the consultant's report is going to be submitted into evidence and become a part of the record. and can be the basis for a decision to be made by the commission. So the right way to reconcile these concerns, the due process concerns of Article 1, Section 22, Administrative Procedures Act, of the requirements of Act 62, is to treat the third-party consultant like an expert witness testifying in federal court for the court as a court's expert. And we have proposed revisions to the regulation that would make it clear that the third-party consultant is subject to discovery, must testify, be subject to cross-examination, and would give the parties in the proceeding a full opportunity to understand the third-party consultant's views, opinions, and to cross-examine on that and to respond to it. We think the right way to treat the third-party consultant for purposes of the ex parte requirements is to say that the third-party consultant is more like ORS and less like the commission staff. We cited the utility services case from 2011 in our comments. In that case, the Supreme Court considered the roles of the commission and the ORS as a result of Act 175 of 2004, and the Supreme Court approved of the provisions of Act 175 that put the advocacy role at the ORS and the decision-making role in the commission. And everybody on the commission is aware, ORS is subject to ex parte prohibitions just like any other party. And cannot have private conversations with the commission, and that's what this consultant should be treated in the same way. Consultants should not be permitted to have private contact with the commission because the consultant's opinions and report are going to be submitted into the record. So all of the appropriate legal protections that need to be put in place in this regulation flow from the fact that the consultant's report goes into evidence and becomes part of the record. So we would urge the commission to reconsider the proposed regulation, to make the revisions that we proposed, which are shown on a red line version that was an attachment to our October 2nd submission. And happy to answer any questions about our views on this, and appreciate the opportunity to speak on behalf of the Duke companies this morning.
Thank you, Mr. Ellaby. Appreciate that, your presentation. I'm hesitant to, do the parties agree that I don't need to go through and ask the parties if they have any questions of each other, that those questions should be limited to the commissioners? Because I have a feeling that in your presentations, there's going to be some discussion of each other's comments, potentially. Does any?
We agree with that, Madam Chair.
Dominion?
Madam Vice Chair, we agree with that as well. Johnson does. This is Weston Adams.
Okay. Dominion?
And we agree with that approach as well, Madam Chairman.
ORS? ORS. Okay. Did I leave anybody out? Commissioners, any questions of Mr. Ellaby about his presentation?
We agree that ORS is on.
Thank you, Mr. Nelson. Commissioners? Mr. Ellaby.
Madam Chair.
Commissioner Irvin.
Thank you. Mr. Ellerby, good to see you this morning. Thanks for being with us.
Hello, Commissioner.
I'd like to hear your view on how this might lengthen the proceedings if all parties have the right to discovery. Does that concern you?
I'm I'm sorry, Commissioner, I'm getting some feedback. I couldn't understand your question.
If we chose to adopt your recommendations, don't you think that would unduly lengthen the proceedings?
I don't think so, just Mr. Chairman. First of all, it would, what we're talking about here are fundamental rights, fundamental due process rights of being able to confront witnesses and to cross-examine. I don't think it would prolong things. We have proposed some time limitations in our revisions to the regulation. I think it actually would be very helpful to have the people testify, the third-party consultant actually testify. The commission would be able to hear. The cross-examination would probably enlighten everybody involved in the case, and I think it would be helpful in getting good decisions made.
Excuse me for interrupting just a second, but we're getting some feedback, so I may need to ask that if you're not speaking to mute your microphones, please. I apologize for interrupting, Mr. Ellaby and Commissioner Irvin.
I think I'd finished my response to Commissioner Irvin. Thank you.
All right, sir. Let me tell you what my concern is, and then let you respond to it if you'd like. Since the statute specifically states that the expert's duty is to the commission, and since we have a right to consult with the expert, you're going, in the course of discovery, you're going to want to see all of our correspondence back and forth and suggestions and comments, I guess?
No, the Act 62 says two things about the role of the consultant that have to be reconciled. And one is that the consultant's duty is to the commission, and the other is that the consultant is bound by the provisions of the ex parte restrictions in Title 58, 58.3.260. The way to reconcile those is to treat the consultant like an expert witness for a court's expert witness, where the expert would not be treated like a staff member for the commission advising you privately. Instead, the third-party consultant would be treated like a party for purposes of ex parte prohibitions, and would testify like an expert witness for a court. So we think that's the way to reconcile that, Commissioner Irvin.
Well, just to give you a specific example that comes to mind, if we treated him like an expert witness, him or her as an expert witness, like you would in federal court, you'd have the right when you depose him or her to see the file and to review any communications with the commission. Wouldn't that be true?
Well, under our view, the consultant would not be having any private communications with the commissioners. So we don't believe, we believe that the ex parte prohibitions would prevent the third-party consultant from having private communications with the commission. So they might be subject to discovery, but we don't think that there would, we think that those would not be permitted for the third-party consultant.
So the position, as I understand it, then the position you're taking is we can have an expert that's duty bound to follow our directives and instructions in terms of what materials and what recommendations we want, but we can't talk to him. Isn't that essentially what you're saying? We can't communicate with him?
No, you can communicate with the third party, the consultant, And that would be done as part of the procurement process. And you could give the consultant instructions on what they're supposed to do to carry out and reach their independent conclusions and prepare their report. All of that just needs to be done publicly and not privately.
Well, let me ask you this. What if the expert submitted a preliminary report for our review and consideration? Should you be allowed to cross-examine him on any preliminary report?
I don't believe under the ex parte restrictions, applying the ex parte restrictions to the third-party consultant, if the consultant came up with a preliminary report, that report could not be transmitted to the commission privately. It would have to be submitted so that all parties in the proceeding could see it. I think you may be on mute, Commissioner Urban.
No, thank you. Assuming that we give instructions and the independent expert commission witness leaves something out, or we want something fully developed as it relates to his recommendations, are you going to be privy to that information as well in the course of discovery?
Well, I think that if the commission, and your hypothetical, as I understand it, the expert prepares a preliminary report, is submitted to the commission, it's done so in a public filing, publicly available, and if the commission concluded that the preliminary report failed to address things that should have been addressed, then those instructions to address additional issues would be done publicly, would be done in a communication that would be made in the docket and available to all the parties.
So if you follow that logic out to its ultimate conclusion, I guess you'd also have the right to depose the commissioners and ask them why they chose to expand the scope of his work.
No, sir. I don't think that follows, and we would not suggest that we would be entitled to take any discovery of any commissioners under the hypotheticals that you've been presenting.
Well, if we communicate with him, you're going to want to see that in the course of discovery, I suppose, right?
But I think what I explained was that those communications from the commission would be done in a way that would be transparent in part of the docket, and therefore available to all the parties. So all parties would be copied by your when you gave instructions to the consultant.
Well, in the course of your practice, I'm sure you've had this come up where you hire or retain an expert, and in the course of that attorney-expert relationship, it becomes apparent that this expert that you've hired either doesn't have the expertise that's needed or doesn't support your position. What if that happens in this case? If we have an expert that we think was qualified to serve, and it turns out he or her is not, we want to go a different direction. How is that going to be handled?
Well, I think this is different. This is more like a court bringing in an expert to, as we suggested, Federal Rule 706, and not like a party sifting through, working through various experts and getting reports that are not subject to disclosure and that kind of thing. So I think this is a different situation. And I believe that the only way to reconcile the role of this consultant being submitting evidence into the record, protecting parties' due process rights of cross-examination, of confrontation, of having notice of what you're being asked to respond to. The only way to do that and protect the ex parte and comply with the ex parte provisions is to have the communications between the commission staff, and this consultant to be done openly as something that is automatically copied to all the parties in the proceeding.
Would you be satisfied if we required the expert, the commission expert, to testify and be subject to cross-examination, and then you'd have an opportunity to respond if you wanted to call a rebuttal witness? Would that satisfy you rather than having to do full-blown discovery?
We think that the having the expert testify and be subject to cross-examination is critically important, but we do think that there needs to be an opportunity to have an opportunity for discovery. Exactly how much of an opportunity is something the commission would have. You know, we've made a proposal about discovery. We think that some discovery is necessary in order to prepare to cross-examine. These are complex subjects, so we think both things. We think an opportunity for discovery and for cross-examination. All of that is required.
Thank you, sir. I have no further questions.
Any other commissioners with questions? Mr. Ellaby, I have a question, please. The statute 5841-20 subsection I states, any conclusions based on the evidence in the record and included in the report are intended to be used by the commission along with all other evidence. And my question is this: if the expert is to evaluate all the evidence in the record, how is he to submit a report before the hearing? Because there is evidence that's coming out in the hearing that may not be included in all the pre-filed testimony. So I'm concerned, or I'm questioning, how is his report to evaluate all the evidence in the record before the conclusion of the hearing?
That's a good question, Commissioner. But it's also clear that the experts report is going to be coming into evidence. I would suggest to you that the expert there'll be pre-filed testimony from all the parties. The expert has the opportunity to fully investigate the positions of the parties by submitting data requests and discovery. I think the expert is going to know what the positions of the parties are, and will be able to address those in the report. I do not believe that the expert can have an opportunity afforded no other party in the case or no other participant in the case to comment after the record is closed for everybody else on the positions of the other parties and submit in a report after the fact responses to other people's submissions that other folks don't get a chance to respond to. I think the statutory provision needs to be construed to avoid something that would deprive the parties in the proceeding of their due process rights to respond to the evidence submitted by all the parties. So you've got to close the record at some point. The way to do that is to have that third-party consultant submit its report ahead of time and defend the report at the hearing, and then close the record.
Well, let's say that were the procedure. What if information came out at the hearing that may make him want to or her to rethink a conclusion or other, or conclusions that they've put forth in the report?
But that's a very good question, and we have, that we've gotten close to that issue being presented in contested hearings when the commission asked for late filed exhibits. It has seemed to me, and I think we've even done it in some occasions, that it is important that if something does come up at the hearing, that and the commission decides, well, we need an additional submission to address an issue, that due process requires that all of the parties in the case be allowed to respond to whatever is submitted as a late filed exhibit. And I think that's the type of procedure that ought to apply to your hypothetical situation. And that the utility services case, which I think Mr. Willoughby argued in the Supreme Court, or at least tried the case that was decided, that the Supreme Court reversed in part on the grounds that that things came up at the hearing that the commission took into consideration that the utility had not had an opportunity to respond to. So I think if something comes up at the hearing, and that's, this could definitely happen, and the commission decides we need to take some additional submissions, then all the parties are going to have, you're going to have to give all the parties an opportunity to respond to that.
That opens up a whole can of worms of how do we proceed with, how do we get to these hearings? I, for one, don't like late filed exhibits, and I've had to ask for them a few times, but how do we get to where we are in these hearings, that everybody can answer the questions that are asked, that are relevant to the proceeding? Just because I just think we need to get to the point where, and this is something for another day, I'm sure, but we just need to get to the point where our hearings, parties can have witnesses that can respond to the relevant questions in those proceedings without those late filed exhibits. That's just one commissioner's opinion, but as we go forward, maybe we'll get there. I like to think of utopia, I suppose. Thank you, Mr. Elby. I appreciate your answers to my questions. And I appreciate your presentation this morning as well. Let's see. Next, we have Dominion, and that would be Mr. Willoughby.
Good morning, Madam Chair and Commissioners. On behalf of Dominion Energy South Carolina, we really appreciate you giving us the opportunity to present our views today. And our views will be very consistent with the comments that you've just heard from Mr. Ellerby on behalf of the Duke companies. The fundamental issue that you're going to have to deal with, and that this regulation attempts to deal with, is making sure that you have a system that's very fair and appropriate for ensuring that everybody's due process rights are protected. And what I'd like to do is say, this maybe addresses one of the questions of Mr. Irwin as well, is the thing the commission has to do, in my judgment, and I say this most respectfully, I've always been very careful over the years, is never to tell the commission how they should do anything. But we would make, if you will take these comments today as our suggestions as to the way that you would ensure that the parties are all fairly treated. And that, as a judicial body, is clearly what you're attempting to do, and what you always attempt to do, is making sure you're conducting a very fair hearing. And in doing so, the one thing you have to always guard against is becoming an advocate. Years ago, and many of you on this call remember when the commission had its own staff, and the commission presented its own witnesses. The staff would testify, and I've actually presented staff witnesses to testify before the commission in proceedings before. And all of that was changed with Act 175 in 2004. And all of those responsibilities were taking out of the commission's role and placed into ORS's role. And the commission became purely a judicial body making decisions based upon the facts that were presented to it on the record. Nothing outside of the record. One of the most or strongest ex parte rules were put into place to ensure that improper ex parte conducts or contacts were not allowed. And so that's the very basis that I start with. And I'm going to see, Madam Chair, if I'm good enough, and you'll bear with me for a second. I'm going to try to share my screen and put up these red line comments to this proposed regulation. But before I do that, Madam Chair, may I have the pleasure of also, Dominion Energy had filed comments back on February the 13th in this docket, and I would move that those comments be made a part of this record of this hearing at this time.
Yes, Mr. Willoughby. Dominion's comments from February 13th, 2020 will be marked for identification as hearing exhibit number 3 and entered into the record of this case.
Thank you, Madam Chair. And I would also ask that the comments that I'm making to you today, I have put these comments in writing. Obviously, I'm not reading the comments, and so I may vary from the script a little bit. But at the conclusion of the hearing today, and I don't know what the right process may be, but I'd like to submit these written comments that will include this red line version of the proposed regulation that I'm getting ready to share with you. So maybe the next hearing exhibit could be the comments. They'll be dated today, and if the correct way to do it is for me to email it to Ms. Boyd and into the record, we can do that. We can file them into the record after the hearing. If you will just give me some guidance as to how you would like me to get them included, but I'd like an exhibit reserved for these written comments to be included in the record as well.
Mr. Willoughby, we will hold hearing exhibit number 4 for those written comments and your red line. I would ask that those be submitted to, I think it's contact@psc.sc.gov. And if you would make sure to copy all parties on that, that would be a big help.
Thank you very much, and I'll do that immediately at the conclusion of this hearing, Madam Chair.
Thank you, Mr.
And so now I'm going to try to share my screen. And guess what I'm trying to do? Have I successfully put it in front of you?
We're not seeing that yet, Mr. Willoughby.
Okay.
There we go.
I'm going to ask my paralegal to come around here. You'll see her in the...
We see it now. Is there a way to enlarge it, either there or here?
Let's see if I can.
We cannot enlarge it, I'm told.
Yeah. Come here and see if we can just, all I want to do is put up this one right here. Maybe I do this. Right. The screen. Good.
Look over, Mr. Willoughby, look over on the left. There's a bar over on the right-hand side, left-hand side. You see the gray bar? I think the third button is a magnifying glass.
I think Laura Lee is going to come here and make sure we get this done by a professional. So you can see the document now.
We see the page, Mr. Ellaby, but it's too small to see. What we were seeing on our screen was a bar, a vertical oval on the far right that looks like it might have a plus or a minus or a magnifying. There are four little symbols there. I can't tell what they are, but I don't know if you see that on your screen. That's visible on ours. Right. I don't know who moved the cursor, but right wherever that cursor was. No, just the red line. Mr. Willoughby, could we take a 5-minute break and have you email those to us, and you email the other parties, and then, or if you email it to us, we can put it on the Elmo? Is that correct? Okay, if you can email that red line to us or to Joanne Wessinger Hill and to the other parties, we can put it on the oh, there we go. That's better. We can sort of see that. I can see lines. Oh, that's even better. Commissioners, can y'all read that?
Yes.
I think we can make that out now, Mr. Willoughby.
Happy to do the other as well, Madam Chair, if we if it would be helpful to email it. But I'm set to go if this is a good enough visual that you can at least follow along.
I think we're commissioners. Okay. I think we can make do.
Okay. So let me begin with the very first section here, which we've titled in the red line, differently from the rule that is being proposed, prohibition on ex parte communications. And again, when we look at the law, the statute, when you look at subsection I, the language is very clear. It says the qualified independent third party is subject to the same ex parte prohibitions contained in Chapter 3, Title 58, as all other parties. Now, they're not made a party to the proceeding. The independent expert is not. But their ex parte obligation is the same as all other parties. And of course, as the commission knows, that means, and this goes to Commissioner Irvin's question, is I don't think you can communicate with the expert and say, we'd like for you to consider this, we'd like for you to consider that, unless you do it openly and publicly and say, we want the expert to do this, this, and this. I think what you are permitted to do is obviously you interview, you hire, and if you look at the hiring process you use, is you're absolutely, and you're very good at this, you're looking to make sure you retain someone that's unbiased. And that's what everybody wants. They want unbiased information. They want to be, you want your expert to be able to provide you the unvarnished truth. You would, when I advocate on behalf of a client, we do our very best to present evidence that is credible and provide you with the facts. But obviously, we are an advocate and we have a point of view. The other side, Weston Adams and his clients, they have a point of view and they're trying to present that point of view. This independent expert and the commission has no point of view. Your job is to find whatever the particular statutory requirement says the issues are for this particular proceeding. That's what you're trying to do. That's what good judicial officers always try to do. So what is the role of this expert, the consultant? And Commissioner Belzer, you hit on a point that's an interesting kind of a conflict, if you will, in the language of subsection I. But the first and primary responsibility for the independent expert is this, and quoting directly from the statute, the commission shall engage for each utility a qualified independent third party. And it does refer to them as a third party. Don't think they're using the word party in that context to mean a party in the proceeding. To submit a report that includes the third party's independently derived conclusion. Independently derived conclusions. And Commissioner Belzer, that conflicts a little bit with that other sentence that you've read a little bit later in subsection I. But I would suggest to you, just like Mr. Ellerby proposed, is that the expert, when you retain that expert comes in without any bias, without any concept, I'm going to punish somebody, I'm going to reward somebody. They're looking to find, in this particular case, we're talking about avoided costs. They're looking to find what is the true and accurate avoided cost that should be passed along in this process. And of course, the reason that's important is to the extent you don't get that number right, then someone's going to be rewarded, i.e. the customers may be charged more than they should be charged, or someone's going to be subsidized. And your goal is to try to make sure that none of that happens. That's a statutory responsibility. So the thing that this expert is responsible for, that's his statutory role. And I think, Commissioner Irvin, what you would do is when that expert is hired, you give him a copy, him or her, a copy of this statute, and you say, the law is very clear. Your obligation is to develop an independently derived conclusion. And how do you go about doing that? Well, obviously, you've hired someone with expertise. It's someone that's been involved in these processes before. They understand what they need, and they're able to interrogate. So they're able to serve discovery on the company. They're able to get data from the company. They're looking, because it's a numbers-driven process, they're looking to try to discern through that investigation what the avoided cost really is. And we're all trying to discern that. Mr. Adams and his clients trying to discern it. They may have a little tilt towards wanting that avoided cost to be as low as possible. The companies are trying to determine that avoided cost. And if, there's all kinds of debate, you'd think the company would try to be as they want the number to be correct. They don't want to overcharge anyone. At the same token, they don't want to undercharge. That is their goal. And of course, that's what the commission is trying to do. The sentence that you read, Ms. Belzer, then says the qualified independent third party's duty will be to the commission. And then it goes on to say any conclusions based on the evidence of the record. So I think what you've got to do is this independent third party cannot be an advocate. The commission cannot be an advocate. You're looking to find the truth. So to Mr. Ellerby's points, and we'll come to that in a moment, through the discovery, I think the independent expert is going to have to interrogate the process, get the information that they get, do their independent analysis, develop their report, submit that report to the commission and to all of the parties, and be prepared to defend that report and explain the reasons behind the opinions and decisions that they're recommending. Be able to withstand that on cross-examination. That's the way you test all pieces of evidence. So I think that's what they have to do. And so therefore, by necessity, they're going to have to develop that report in advance of the hearing, file it in advance of the hearing in sufficient time that all of us then have the opportunity, not just us, but Mr. Adams's clients, because they may disagree with what the independent expert might say, and they might want to test how he or she came to their conclusions. So every party should have that right in order to have a fair hearing in a search for the truth. But the ex parte rules are very clear. What I read earlier, the qualified independent third party is subject to the same ex parte prohibitions as all other parties. It doesn't say maybe. It doesn't say sometimes. It doesn't say we can talk with you for a while, but then that ends. It says they're subject to the same ex parte rules as all others. So when you're asking yourself the question, how far can our contacts go? All you have to do is ask yourself, well, how far could we go in contacting Duke, or in contacting Dominion, or in contacting Johnson Development? How far could we go in contacting them without the other parties being aware of that contact? And I think the answer is that can't be done in that setting. You have to do it open and transparent, and if you want to give some instructions to the independent expert, then you'd need to give those instructions in a way that everybody would be aware of them and could make inquiry about them if they chose to do so. I certainly don't think, to Commissioner Irvin's question, I don't think any of us, and I don't think the commission exposes itself to us conducting discovery against the commission. That's not the intent at all. But I think you are constrained, the commission is constrained by the plain words of this statute as it pertains to ex parte communications. And I think you're also constrained in your judicial role, that you cannot advocate for a position. You can't advocate for this independent expert to take a particular position. You can certainly say, when you're interviewing the expert, you can say, well, how do you go about determining your independently derived conclusions? And you could certainly say, would you ask this question, or would you ask this question? Would you investigate that? Would you do that? But you're hiring an expert that has the credentials and the ability to make an informed investigation and then make a report and be able to explain the reasons behind the recommendations that he or she might make. And I think this statute provides the clear guide as to what they're going to do. So that's our view, and you'll see these red line provisions here addressing the prohibitions on ex parte communications. And I believe most respectfully that the regulation as currently proposed directly conflicts with the statute. And as all of the commissioners know, you cannot issue a regulation. Your power and your jurisdiction is derived from the statute. And to the extent you put into or craft a regulation that either exceeds that power that's been given to you by the General Assembly or that is in direct conflict with it, the regulation is void. Therefore, I would argue most respectfully that the changes we propose to Section A absolutely have to be done. Otherwise, you're going to be in direct conflict with the statute, in my opinion. Now let's go to subsection B, and it talks about the role of the expert that I've talked with and I've read directly from subsection I. You'll see this language mimic directly from the statute, the consultant's independently derived conclusion. And of course, the only evidence, and it's not evidence at that point, Commissioner Belcher, as we all know, but the process that has developed over many, many decades at the Commission is that all testimony is pre-filed, the testimony is pre-filed, reports are attached as exhibits. So the expert would have the opportunity to look at those pre-filed pieces of testimony and could draw some conclusions from that in advance of the hearing. And as we all know, the Commission regulations over time basically says that when we pre-file our testimony, we are largely constrained. We can address things that might arise that are new, that may come up at the hearing in rebuttal testimony. But we're mostly required to prepare our testimony in advance, file it, and when we summarize it, we stick to that pre-filed testimony. We submit it into the record. If there's some edit or correction that needs to be made, we make it. But then we pretty much adhere to that pre-filed testimony. So to the extent the independent expert wishes to comment, and I would say that's you have to be careful that expert does not become an advocate, and I think that would be one of the things that you would want to certainly instruct an expert against, is you're not an advocate. Your role is defined by statute, and we are hiring you to fulfill this statutory responsibility. And that role is for you to make an independently derived conclusion based upon the data that you get from the utility. The utility has got the facts and the figures and the numbers. You get that data from the utility, and obviously the expert also will rely upon his or her independent training, experience. Many of these people have PhDs, and so they're dealt with these issues in many, many situations in the past. So they're giving you the benefit of that training and knowledge, and of course giving all of us the benefit. So that's how we define the role. We think our definition of the role sticks more closely to the statutory language, and we are concerned, the reason we make these red lines, we are concerned that the role that has been defined in the proposed regulation may expand the responsibilities. And of course, we all know that Commission regulations can fill in gaps where the statute does not, for example, a time period or something of that nature. But I don't think the regulation can assume responsibilities that were not provided by the statute itself. And I believe under the role that the responsibility may have been expanded a little bit. And we think the way we're proposing to revise it is more consistent with the statute itself. And then we come to discovery, and Mr. Ellerby spoke about this. It's just fundamentally a violation of due process to be able to put evidence into a record that a party, and we may totally agree with it. And if we do, then obviously we don't need to test it. But there's likely to be some party on one side or the other that may have some issue. Or they may not understand, and they need the ability to understand and test. And the only way you can do that is through the discovery process. We think the underlying provisions of 584120 makes it clear that discovery is permitted in these proceedings. And we don't think there's anything that exempts the independent third party from that. And we would argue that these things are absolutely required. Obviously, subsection 1 under C discovery just talks about submitting everything in a pretty much open view. I'm sorry, I carried it over. Then the qualified independent expert subsection 2 shall notify the parties of the proceedings, and obviously you would expect that largely through his or her report. Would be subject to being deposed, may be called, do not necessarily have to be called, but would be subject to being called if all of the parties decided that they didn't have any questions of the witness. Their testimony and or report could be moved into the record at the hearing and without cross-examination. But if any party wanted to cross-examine that witness, they should be given the opportunity to do so. And also, in order to test their report before we get to the hearing, we would need the right to be able to interpose a written discovery responses to them to be able to understand the data that they found to be important for their report. We think this is absolutely fundamentally required. We think it's required to protect every party's due process rights. We think the statute itself permits it. And as Mr. Ellerby said, Article 1, Section 22 of the Constitution, we think provides for it. We think the Administrative Procedures Act provides for it. So we believe our proposal regarding discovery related to the independent expert is mandated by those constitutional and statutory provisions. And then we come to subsection D, the report. It is not fair and it is not due process to close a hearing, have this independent expert have his or her work done in secret, and then toss it into the record, if you will, after our opportunity to ask questions, rebut, and provide an opposing point of view. If we have one, we may want to provide a supporting point of view. But whatever our view might be of the independent expert's work, we need the right to be able to put it into the record and tell the commission what that view is. And the only way to do that is we certainly have no problem with the independent experts testimony being filed last if the commission, and you can do that in your scheduling. The utility is generally providing their testimony first, then the intervening parties and ORS next, then rebuttal and surrebuttal. You could have that whole process, but you need to have enough time in there that then if this independent expert, when they file their report, we need to have at least 25 days. And there's a couple reasons for that. One, if we do any discovery directly related to the report, the commission's rules say we got to give them 20 days notice of the discovery. Now, you could address that by shortening that discovery period for the independent expert to say 10 days, and that might truncate that process a little bit. But we propose 25 days before the hearing, gives us enough time to interrogate the process, decide whether or not we want to depose the independent expert, get that information done, and then decide whether or not we need to submit some testimony rebutting one or more presumptions. It could well be that the independent expert just misconstrued something. They've got numbers wrong, and we need to point that to a mistake out to the commission. We need the right to do that. When the record is closed, when the commission stands down and says, we're closing the record, we'll take this matter under consideration, we'll let you know of our decision, the record ought to be closed. And Commissioner Belzer, to your point, I believe the independent expert, to the extent, and there's always the concern when they start commenting on the evidence, you can't delegate to them your judicial power. There's nothing in this statute that does it. They are nothing more at the end of the day than an independent expert that you have, hopefully everybody will have confidence in their credentials, the fact that they're unbiased, the fact that they're giving you a straightforward facts, seeking the truth, trying to give you the best information that they can, but they can't become an advocate and you can't delegate to them your decision-making power, your judicial responsibility to base your decision purely on the facts of the case. And the statute is very clear that all you will do, you'll consider their evidence or the information provided by them as all other evidence. And I had the occasion to try a jury trial not too long ago, and I've got the jury charge here where it says the decision making, the jury, the judge gets to weigh the evidence of all of the witnesses and may believe some over others, and may believe one against many, may believe many against one, may believe some of the testimony that a particular witness may present and disbelieve the others. So all of that stuff, the credibility of the witnesses, you can't delegate that. All this independent expert can do is give you information about the facts and their calculations and their determinations. You shouldn't be asking them, in my humble opinion, and you should not permit them to testify about the credibility of someone else. All they can do is say, here's the information and data I collected. Here's how we calculated it. Here's what the numbers we believe show, and here is why we believe this to be true. So time is important, and Commissioner Belzer, I think they're going to the extent they want to comment about the data that the company may have submitted, or the data that Mr. Adams's witness may have presented, I think it would be largely focused on why that information, the numbers they disagreed with, why they disagreed with it, what the numbers they think are the correct numbers, without trying to editorialize about whether they believe witness A is credible and witness B is not credible, that sort of thing. Courts generally, on very limited circumstances, they allow people to even comment on the credibility of someone else. That's a unique situation for the commission to make a determination about the credibility of the witnesses based upon their presentation, based upon how they withstand cross-examination, and you judge all of that, all the way from body language to how they responded to questions, whether or not it just passes the smell test, all of those things. And that is the commission's unique role and responsibility as a judicial body and something that cannot be delegated, and the General Assembly did not delegate in a subsection I. And I believe, I think that summarizes to the end of this proposed red line, Madam Chair, and I believe that concludes the remarks that we've got, summarizes them hopefully effectively and understandably. But if not, I stand ready to address any questions that anyone may have.
Thank you, Mr. Willoughby. I'll proceed with commissioners. Are there any commissioner questions? Commissioner Powers.
Thank you, Vice Chairman. Mr. Willoughby, and not to get into just pure semantics, but I mean, we're talking about a statute that talks about someone being qualified and independent. And in your presentation, it seems like there's an automatic opinion that this person would be biased, but that your client's experts, and your advocacy, you called it a point of view. What's the difference between a point of view and a bias that you could kind of enlighten me on?
Well, the commissioner, when you hire any expert, experts come from varying backgrounds, just like.
Mr. Willoughby, I'm sorry, we're having a technical issue. Mr. Willoughby, can you unshare your screen for us?
Let's see if I can here.
I'm sorry to interrupt.
No, that's Did that do it?
Yes, sir, we can see you now. Thank you.
Okay, perfect. A point of view, what I meant, Commissioner, was simply that every witness or every individual comes to whatever issue they come to with. We're all a product of our experiences over many, many years, and people that are trained, that have PhDs or masters, they're trained, and you see this all the time from schools of thought. You'll see the University of Chicago School of Thought versus Stanford School of Thought, and those are sometimes competing points of view. Well, experts may have those same sorts of viewpoints. And all I meant by my comment was that what you're trying to do is not hire an advocate. What you're trying to do when you hire an independent expert is you're trying to get someone that is truly independent, someone that is going to be able, but also qualified to be able to take the information from a utility, and this is highly technical information, a lot of data, and be able to analyze that data, make a report, and essentially assist in calculating what they believe the avoided cost to be. And so, I mean, it would, for example, if you were considering an independent expert that had just testified last week in North Carolina or on behalf of solar developers and had one point of view, that might be a fact that you'd want to consider as to whether or not it would be appropriate to hire that individual as your independent your independent expert and consultant. And that's all I meant by the comment about point of view. You're looking as well as you can, and interestingly enough, commissioners. I mean, you've got great experience, you've got great backgrounds, and you bring all of that to the table. And sometimes you're almost having to put aside a personal point of view and trying to look at the evidence in front of you. And so that's kind of the point I would make on how points of view may figure into this equation.
Well, I would have to assume that if someone works for industries over and over, they would be considered to have some sort of bias, or that could be assumed. We don't have the Federal Rule 706 in South Carolina. I just think there's maybe not enough emphasis being put on the word independent, which is in the title of the statute. But you've answered me. Thank you.
Madam Chair.
And Commissioner, I would add that the word independent is in there, and I think that informs your judgment as to what you're looking for is someone that truly is an independent and does not come to the engagement with any preconceived ideas as to where he or she would like to see the issue come out. And rather than saying, here's where I want to end up and let me figure out how I get there, but rather get the data, analyze the data, and then say, based upon this analytical process, a process that's tested and true, here is what the data and the information would show based upon my independent analysis of it. And if I may go one further step, is you got to be careful, I believe, in all due respect, you have to be careful that you don't assume that just because this independent expert has given you this analysis, that is all you're going to do. Okay, we're going to have this hearing, but the hearing doesn't mean anything because at the end of the day, we got this independent expert. We're going to, whatever he or she says, that's all we're going to do. That's not what the statute says, and I don't think that would be faithful to the role and responsibility of the commission. That independent expert is information that you will evaluate along with everything else in that particular hearing.
Vice Chair Belcher.
Commissioner Caston.
Thank you, Mr. Willoughby. Appreciate your presentation, very helpful. I think it was item B where you talked about the role of the consultant. Excuse me. Are you saying, and I'm going from memory, I was trying to read it on this small screen up here. Are you saying that the contractor should simply review the information provided from the utility and not run independent modeling or look at their own numbers or whatever their expertise is?
Commissioner, very good question. And no, that's not what I'm saying. Obviously, the expert comes with capability and knowledge and experience and training. And what that expert does and should do to inform his or her judgment and to be able to inform their report, and so they can provide valuable evidence to you, is they should take the data. They should know what data to get. They should know what data to analyze. They collect the data. They collect the information. And yes, we would fully expect that they would have models that they might use. They may develop models. There are models that are widely recognized. But yes, you would expect them to do their analysis. That's part of their analysis. No, it would be a little benefit to you if they just collected a lot of raw data and put it in a spreadsheet and just spit it out. That wouldn't do much good for you. You need their analytical skills to be able to take that data and try to model it and make a recommendation. Because at the end of the day, what is the avoided cost is the issue that we're all trying to grapple with. And that's what you're going to be expecting them to help you make that determination.
Thank you. In the earlier discussion, I guess, about bias, excuse me, you know, I suspect everybody has some bias about something. But I guess my thought is as long as you're biased and honest, you know, it's okay. And my point that I'm trying to make, making poorly probably, in a former role, we used consultants frequently. And I was biased in that I wanted what was in the best interest of the district and our customers. But never once did it cross my mind that I wanted a biased study. I wanted the truth. I wanted to know, okay, what do we need to do? Tell me the truth. I may not like it, but what do we need to do? It appears to me, at least a non-attorney's view of looking at Act 62, and the genesis, I suppose, or I suspect, the genesis of this addition to Act 62 probably had something to do with past events. You know, was there adequate information? Did it feel like there was adequate information? And I guess that's always the question. The utility provides information. They're experts. I understand and get it that from your perspective, your client's perspective, you want to make sure that it's honest, accurate. You have the ability to question it. You don't want me or any of these commissioners to ignore all the other information and just use an expert that would, whose duty would be to the commission, just use that information. Is that a fair statement?
That is a fair statement, and it goes, Commissioner, to the role of this independent expert. And as I used the words before, your responsibilities and decision-making, your judicial powers have not been delegated to this independent expert. The statute makes it clear that this independent expert will provide you a piece of information, but all of the other information in the record will have to be considered as well. And you might actually find, and part of the reason I would argue that you as a commissioner and all of the commissioners really will be better served by what we have proposed here in the red line changes to the regulation. You will be better served by having that expert take the witness stand and withstand cross-examination, withstand the questions, because you'll be able to see him or her respond to the questions. You'll be able to see whether or not, because you really won't know how they've gone about doing their analysis. So some of those, you won't be able to sit down. You won't be able to bring them into a conference room and put them at the head of the table and all of you sit around the conference room and just have a private meeting with them, because the ex parte rules prevent you from doing that. So how then will you get the information to see whether or not truly this person that you have engaged, and if you've never engaged them before, you have no track record with them. So to truly see how they may be how credible they may be, how credible their work may be. And when I say credible they may be, I don't mean to imply at all that they come into the equation with any idea that they're going to try to do something unfair. They just come in with whatever viewpoints they might have initially, and through the interrogation process, through cross-examination, you get a chance to see that information tested, and you come away believing that that information is actually very credible, very true, very well done. Or you may come away and say, well, you know, I think they may have missed this, or they may have missed that, and maybe I can't place as much emphasis upon what they may say.
So it appears that we're in agreement that the third-party expert, all the other experts of the utility and the other parties, all of that information should be considered equally.
It should, yes, it should all be considered, and it should withstand the test. I mean, our judicial process, the adversarial process that permits cross-examination, while everybody has written widely about the process, I would be one of those that would say there's no better process in the world, bar none, than the process that exists in the U.S. And that process throughout time has been based upon the ability to cross-examine a witness about their information, about their views, about the report that they have submitted, and that allows you to see whether or not that report withstands that test. The questioning of whether, did you consider this? Did you consider that? Why is this more important than that? And that, I think, informs your judgment and allows a decision that the commission might make in a given matter to be a better decision.
Yes, sir. Thank you, Mr. Willoughby.
Any other commissioners?
Madam Chair?
Madam Chair?
Commissioner Williams.
Thank you. Mr. Ellery, my question comes more from intent. And of course, I know that the statute is what we're working to interpret and to articulate through this regulation. But it strikes me that this was a real specific opportunity that the legislature gave us, particularly for avoided cost hearings. And I wonder if you or Mr. Gissendaner bring any background on the intent that the legislature had in crafting this piece of the legislation, and if that'll help inform us about the current decision.
So, Chairman Williams, Commissioner Williams, I was not involved with the actual development of the statute. I don't know if Mr. Gissendaner has any idea behind it. I would say to you that the first rule of statutory interpretation is obviously to look at the language, and if you can discover the intent from the language itself, that's what you're left with. The reading the act itself, the lead into the act, and I have it right here, says we're trying to do all of these things, and so that gives you some ideas to the intent of the General Assembly. I think from just reading Section I, and then I'll ask Matt if he knows more than I do on some of the background, because you're really asking history background as to the statute. The statute itself says that the responsibility of the parties and the responsibility of the commission is to make a determination as to what the avoided cost is, because it's an important determination. It helps determine what is paid to solar companies for the energy that they provide. So it's hugely important to them. It's important to the utility as well, because we have customers that pay for all of the services, and the goal is, and the statute says this very clearly, is the goal is to make sure that those customers are not part of the are not subsidizing the solar companies. We obviously, the state has announced that they're have a policy of trying to develop solar. That's a good policy, but at the end of the day, they are doing it without saying we're going to have our customers, the electric customers, subsidize that process. And so the process that you are having to discern is, okay, where is that number? I can't subsidize, and at the same time I need to pay what is the appropriate avoided cost to the solar companies. So what is that number? Very technical process, a lot of data, and that's what the statute says. But with that, I don't know, Matt, if you have any background about the development of that particular subsection I.
I do not have any background. I was not involved in drafting that particular subsection or any subsection for that matter. I would say that it is difficult. It's a difficult thing and a risky thing to get into the business of trying to discern the legislative intent outside the four corners of the statute itself. Other than if sometimes the legislature will include an intent section in the legislation they pass, but outside of that, to say that the legislature is speaking or that all legislatures in the House and the Senate have the same intent when they pass legislation or draft certain legislation. I don't know that I can say that. A legislator from Charleston may have a different intent than a legislator from Greenville or from Columbia. I hope that's helpful.
That's it.
Commissioner Williams, did that, and let me echo what Mr. Gissendaner said, is at the end of the day, if you ask that question to every member of the House and every member of the Senate, you might get a slightly different answer. At the end of the day, we're all left to taking the legislation that got passed, got signed by the governor, and trying to implement it according to its terms and according to the constitutional backdrop that may inform how it should be interpreted.
I do understand that and respect that. I also know that part of how legislation like this evolves is that there are folks at the table that might have been able to speak to the intent. So, but I appreciate your answers. Thank you.
Commissioner Irvin?
Thank you, Madam Chair. Mr. Willoughby, thank you for your comments. I appreciate many of them. I think you and others that are with us today may have been involved in the first vetting process under the statute, where you may recall I think we brought in at least six. We got dwindled to 5 at one point when someone withdrew. But did you think that was a good vetting process to question the potential expert witness on the background experience and any biases or prejudice it might have?
Commissioner, I do think your vetting process was a good one. It was an open process. Everybody was informed of the people that you were planning to interview. You interviewed them publicly, and people were able to participate in those, or at least observe those interviews. And as I remember, the commission had focused upon selecting someone and then ultimately found something in their background that was troubling, and therefore ultimately redirected from that initial person that you were looking at or considering hiring, and hired someone else. So, but I did not have any. I thought that open process was a good process.
Well, I did too. I thought it provided a lot of transparency for the entire proceeding. And I would suggest if we make changes that be included, simply because it seemed to work well, and the parties even were asked to submit questions of the expert if they had any questions, and we actually use those questions in our voir dire, so to speak, or our review of their qualifications. You wouldn't object to that, would you?
Well, I'm not sure exactly what you're asking, but this proposed regulation, Commissioner, focuses upon the role and responsibility of the independent expert after he or she has been identified. So this particular regulation that we're commenting on today has nothing to do with the selection process, how you go about selecting the person. So we
that addition
obviously
may not be, yeah, it may not be needed in this instance, but I thought that worked well, and everybody seemed to appreciate it. But to my next question, what do you think about having the independent expert file his preliminary report and recommendations prior to the start of the hearing, but after all the parties have submitted their pre-filed testimony? And then once that preliminary report is filed, he'll be called as the first commission witness to testify about his recommendations, and all the parties through their attorneys will have a chance to cross-examine the expert. You think that might be helpful?
Well, I believe I think you're going to need to do it as we suggest here, where that expert participates in the hearing. So I believe, Commissioner, that they will have available to them all of the pre-filed testimony and exhibits that any of the parties have filed. As soon as they're hired, they're able to start interrogating the utility company to collect information from them. They'll be doing their own independent analysis. And I can't emphasize enough that this statute says, and it doesn't equivocate, that they will submit a report that includes their independently derived conclusions.
Right.
And so I think they've got to do that. I think they've got to do that. They can't cherry pick from everybody else. But then to Miss Commissioner Belcher's standpoint of view, any conclusions based on the evidence, to the extent they draw some conclusion either in support or in opposition from something that someone else may file, maybe they put that in additional part of their report. But at the end of the day, I think they've got to file that report at least 25 days out before the hearing, give us an opportunity to review that report, see if any party, not just us, but any party, to look at it, and then be able to submit a testimony to rebut something we might disagree with, or we might put some testimony in support of something that they do. But I think you've got to do that. If you close that hearing and then have them submit additional information into that record that you're going to consider, and I believe I think that's a clear due process violation. and I would urge the commission not to do it in that fashion.
And I was looking for a way to avoid that problem. But to Commissioner uh, Belser's point, if there is new information that comes to light during the hearing, don't you think that it would be we'd be best served to give the expert an opportunity to amend his report and file a final report, and then give the attorneys and parties a chance to reply to it in writing within a certain period of time?
Well, I think, Commissioner, that you've got that with every hearing. I mean, the same issue. I mean, there may something come to light in any hearing that you've got, and you may say, the question you have is, am I stuck with the record? Must I make my judgment on the record? Do I ask for additional information? So the answer to your question is, if something arises during the course of the hearing that the commission believes needs further investigation, then I think you're going to have to let everybody investigate whatever that issue is and submit whatever testimony they think would be important to it. I don't think you can just say, okay, this is a question, it arises out of this, we're going to assign that to our independent expert, have them investigate it, submit a report, and we're going to then rely upon that report. I believe that's problematic.
Well, let me just ask it this way. Wouldn't another way to cure it would be to take it up on reconsideration? If anybody, maybe the parties find the final report to be, helpful and reach a compromise on some issues. You may not want a reconsideration, but if you're offended by the final report, why not allow us to take it up on reconsideration in our discretion to give everybody a chance if they want to cross-examine the expert on his final report?
Well, on reconsideration is typically reserved, Commissioner, to situations where you've issued an order, you've made a finding, you've made determinations, you've decided, made conclusions, findings of fact and conclusions of law, and you've issued your report, your order, and then someone saying, I disagree with it, and therefore I respectfully ask the commission to reconsider it. Typically, you're not receiving additional evidence into the record at the reconsideration phase unless you say, and of course we generally ask for rehearing and reconsideration, unless you decide to fully rehear the whole thing. But I would argue and urge the commission that your goal always is to get it right at your initial decision. And you should develop a record and you should make your decisions, I suggest, based upon that record. And hopefully that record is complete, got all the data in it that is needed. Everybody's had a full opportunity to cross-examine witnesses, to submit what testimony they think is important and reply. All of that's there, your record is complete, and you've had the opportunity as a judicial officer to hear all of that, to inform your judgment when you're getting ready to make your decision. And I would think and hope and urge that you would want that record as complete as possible, and that record should be tested by every party of record, or at least have the opportunity to test any information that is submitted into the record.
Thank you, sir. I appreciate it.
Thank you, Commissioner.
Thank you, Commissioners. Thank you, Mr. Willoughby and Mr. Gissendanner. We've been going about 2 hours now, and I want to give the court reporter a break before we finish. So, Mr. Adams, I apologize for breaking right before your turn, but it is 12 o'clock on the computer screen, and so let's come back at 12:10, please, and be ready to proceed. Thank you very much.
Thank you.
Thank you for that break. Do we have all the parties? We got, I'm informed by our technology that we have our parties with us. Let me do a roll call of the commissioners. District 1, Commissioner Williams.
Commissioner Williams is here.
District 3, Commissioner Caston.
Present.
District 4, Commissioner Irvin.
Present virtually.
District 5, Commissioner Powers. I'm sorry, did I have that right? Thomas,
Thomas is present.
I'm sorry.
It's okay.
Commissioner Williams is out of the hearing room, and Commissioner 7, Commissioner Powers, thank you. And Commissioner Belser from District 2 is present. I believe we are now on to Johnson Development Associates. Mr. Adams?
Yes, ma'am. Yeah, Weston Adams for Johnson Development. First of all, thanks to the commission for letting us be here today and hearing us out on all these issues. It's been interesting and illuminating. Madam Chair, as an initial matter, I'd like to move into the record the two prior sets of comments that Johnson Development has filed. Those were February 13, 2020 and October 2, 2020, and have those marked as the next numbered exhibits, if you will permit that.
Mr. Adams, Ms. Wheat, 5, is that hearing exhibit 5? And Mr. Adams, I think we're having a little bit of difficulty hearing you, if you can talk into the microphone. Those
ma'am.
two sets of comments will be marked for identification as hearing exhibit number 5 and entered into the record of this proceeding. Thank you.
Yes, ma'am, and I'll talk as loudly as I can, and I hope that works.
That sounds a lot better, thank you.
Good, yes, ma'am. And also, when I'm done, Madam Chair, I'd like to submit our written comments after the fact as well, if you will.
Mr. Adams, those written comments will be hearing exhibit, marked for identification as hearing exhibit number 6 and accepted into the record of this proceeding. And as I instructed Mr. Willoughby, would you please email those to contact, CONTACT, at psc.sc.gov, and please make sure to serve all the other parties to the docket. Thank you.
Yes, ma'am, I'll do that. First of all, we'd like to thank the commission for all the hard work that they've done on this regulation. And I would like to note that Johnson supports the regulation as drafted. The regulation as drafted actually matches almost verbatim what Johnson itself proposed here. And so we would request that no changes be made to the regulation. Of course, that's in your discretion as to how this is handled. But we like the regulation as it's currently drafted. Madam Chair and members of the commission, we would reject the concepts of that the third-party experts should be subject to discovery, should be subject to being deposed, should be subject to being called to testify, or should be subject to cross-examination. I don't think any of those things is reflected in any way, shape, or form in 584120I, which is the relevant statutory provision. There's no provision for any of that in there, so we would be making that up out of whole cloth. And I think we would be rewriting the statutory provision if we went down the path of allowing it. So Johnson would strongly argue against that. Madam Chair, I would also point out that the citations to Federal Rule 706 are not relevant here. South Carolina does not have a 706 in its own rules of evidence. And this is a state law matter being drafted under a state statute, and there's no federal overlay here that requires us to go refer to Rule 706. But even if the other parties are going to use 706, they've added to that. There's no written discovery allowed under Rule 706. So they've taken Rule 706, which is not applicable, and made it even broader by adding written discovery to that, which is not permitted. So Johnson would suggest that the relevance of 706 is meaningless for the purposes of preparing this regulation. Madam Chair, I would like to sort of just go to the heart of the matter on the ways the parties have described what this person's role is here. The ex parte provisions do not apply to the communications between this third party consultant and expert and the commission. They do apply. The third party can't go talk to the parties. The ex parte provisions would allow that, but they don't apply to the communications between the third party and the commission. I think that the third party is really more like staff than like ORS, to use Frank Ellerby's sort of the frame of reference that he discussed. I would say I would take the opposite position. They really are more like staff, but also say they're more like a technical consultant than like an expert witness. In fact, they're not an expert witness. They're not going to be called. They're not going to testify. And I would note, importantly, under the statute, their duty is to the commission. That doesn't sound like an expert witness. That sounds like more of a consultant role, to be perfectly honest. You know, and it's interesting, if you look at the language of the statutory provision, I think the parties have gotten a little distracted by the concept of the word that expert is in the statutory provision, but I'm going to read you the several mentions of the party through the statutory provision. At one point, the party is referred to as a third-party consultant and expert. Another provision, the party is referred to as a third-party consultant or expert.
Mr.
And
Adams,
the next three
Mr. Adams, I apologize. Someone needs to mute their microphone. We're getting some feedback. I got that. Thank you, Mr. Adams. Please proceed, and I
I'll try that one more
apologize.
time. If you look at the language of the statute itself, Madam Chair, the language of the statute itself, it uses terms. In one place, it refers to the person as third-party consultant and expert. The next mention is third-party consultant or expert. Then there are three mentions of independent third parties, 3 times in a row. And then the last mention is third-party consultant or expert. So I think that the utilities have gotten sidetracked by getting fixated on the notion of this as an expert, when in fact the statute doesn't even call for that. There's no requirement here that this party be an expert witness. It's whatever you guys want to make of it, effectively is what it is. So I think that, you know, effectively what we're talking about is a consultant more than an expert witness. And I would say that if you have testimonial needs in a given case, and I think Commissioner Irvin pointed this out, you could always consider testimonial needs on a case-by-case basis. There doesn't have to be a hard black and white rule on this. You've always got the authority to call somebody to testify, but you don't have to put it into a regulation. And then I think that the only change that I would propose, the single and only change that I would propose to the regulation, if I were going to propose anything, is to change that the report has got to be provided 10 days ahead of the hearing, make it 30 days ahead of the hearing. I don't see any harm in that. But I think the idea of treating this person like a party or an expert that's got to be discovered, deposed, cross-examined, and forced to testify is going to basically destroy the purpose of the entity. I think the purpose of this is to provide some professional expertise in this setting, not to operate as a party subject to discovery, subject to cross-examination, subject to deposition. I don't think that was the intent of the legislative individuals who drafted this provision. And Madam Chair, I'll pause there and see if there are any questions.
Commissioners, any questions for Mr. Adams thus far?
Madam Chair.
Commissioner Irvin?
Mr. Adams, you make an interesting point. I suppose the commission in its discretion could call somebody as a independent consultant only, and maybe for a very limited purpose. And that seems to be something that they could put in a final report and be done with it. Would you agree with that?
Yes, sir, I would.
And that has some advantages, particularly if it's filed prior to the hearing. The parties can have their own experts review the report and make their observations. Would you agree with that?
Yes, sir, I would.
And it would certainly save a lot of time and cost of litigation to do it that way, because if you go full-blown discovery, so many intervenors and parties, you're interjecting a time delay that could tie us up inadvertently, and this thing has to end at some point.
And there's also an expense question there that, I mean, is the third party supposed to have a law firm representing it throughout this thing, which it would presumably be forced to do if it were subject to all these things.
And the commission is having to pay for all that, I suppose. So it might be that we could just use our discretion on a case-by-case basis, and if we think we need a consultant, we could hire. We could put out a request for proposal for a avoided cost consultant. If we need something more, we could ask for that. Would you agree?
Yes, sir.
Thank you.
Thank you, sir.
Any other commissioners? Okay, Mr. Adams, does that conclude your comments?
Yes, ma'am, it does. Thank you very much.
ORS, I think you indicated you do not have a presentation. Is that correct?
That's correct, Madam Chair. We have no presentation. I appreciate the comments, especially from all of the parties that were here today to speak, but we have nothing further to add.
Thank you, Mr. Nelson. To make the record complete, the chair will ask for two hearing exhibits. By standing hearing officer directive, I believe, was it yesterday, November 3rd, two parties had requested that they be excused, and they both indicated they had filed comments. So if no party objects, I would ask that hearing exhibit number 7 be reserved for comments filed by the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy, dated January 28th, 2020 and February 13, 2020. Or to the extent that I may have dates written down wrong, that SACE and CCL's comments be a composite hearing exhibit number 7, and that hearing exhibit number 8 be reserved for the comments filed by the Solar Business Alliance. And I believe they had initial comments in February and also filed additional comments in October. So that would be hearing exhibit 7 for SACE CCL comments, hearing exhibit 8, SBA's comments, letters. Any objection? Thank you. Is there anything further to come before the commission in this matter from the party?
Madam Chair.
Mr. Ellaby.
There were a couple of points that came up during Mr. Adams' presentation and response to Commissioner Irvin's questions. I don't want to prolong the discussion here. I would request an opportunity to write a letter responding to a couple of points and submit that as the next hearing exhibit.
And Madam Chair, just in fairness here, if he's going to do that, of course, then what is the end of this? I mean, do we respond to that?
Well,
I'll go ahead. Listen, I can do it very quickly on the record.
Well, let's pause here for a second, Madam Chair. How would you like to proceed with that?
Well, under the Administrative Procedures Act, we have to leave the record open for a minimum of 5 days and to receive written comments. if out of an abundance of caution, Mr. Adams, I would entertain allowing Mr. Ellerby to proceed now. He can file his letter, and you'll know what he's going to say, so you can file in response if you like.
That's fair.
How's that? Mr. Ellerby, you want to briefly proceed?
Thank you, Madam Chair. Mr. Adams mentioned a change that he would be willing to agree to with respect to the proposed regulation. And he said change 10 days before the hearing to 30 days before the hearing. The problem with that is the proposed regulation, in response to a suggestion by Johnson Development, currently reads 10 days before the vote. And that the distinction between before the hearing and before the vote is really important. And we've been trying to emphasize that. If the deadline for the report is 10 days before the vote, then that's, of course, after the hearing. So that correction that he described is not consistent with what his client proposed and what is currently incorporated in the proposed regulation. The other thing that I would like to respond to is the questions from Commissioner Irvin about the commission having discretion to decide on a case-by-case basis as to whether to have the consultant testify or not testify or be subject to discovery or not. That would require a revision of the proposed rule. The current proposed rule precludes testimony by the third-party consultant, precludes discovery of the third-party consultant. So if that was the approach the commission wanted to take, the proposed regulation would need to be revised. So those are the points that I was going to make. And if as I understand, other parties are submitting comments summarizing I think that I understand that other people who have made presentations are planning on submitting written comments. And if that is the case, I'd like to reserve the opportunity to submit something in writing that would address the points that I've just made in this response.
Mr. Ellerby, as clarification, I understood that what Mr. Willoughby and Mr. Adams, that they were submitting their comments that they had prepared for their presentation today. And I'm getting ready. You will have the opportunity to file additional written comments. I'm getting to that right now.
That's fine.
Okay.
I'm fine.
Anything else before I get to this part?
Madam Chair, it's Mitch Willoughby. We have just sent the written comments along with the red line attachment that I went over in my argument. So we've just filed that with the commission or sent it to that address that you gave. And subject to, I think you're getting ready to say that we can submit additional comments by a certain time, and we certainly would reserve the right to do that if the commission permits that to be done.
Thank you, Mr. Willoughby. Anybody else? Okay. Under the Administrative Procedures Act pursuant to South Carolina Code Annotated Section 1-23-111B, the record must be left open to receive comments for a minimum of 5 days. Therefore, we will allow any further written comments based on the proceeding today to be filed with the commission until close of business on Monday, November 9, 2020. And with that, I thank you all for your participation. I thank you all for your comments and your excellent presentations today. And this hearing is adjourned. Thank you.
Thank you.